prove to you three things. First, the fact that Storm Jackson's GPS information could and would be provided to police for investigative purposes was fully disclosed to him in the contract that he voluntarily signed. Shannon Gannon has testified that Storm did sign a waiver that informed him that GPS and location data would be collected and used at the request of a police officer, which is exactly what happened in this case. It does not matter if you wish or generally would think your rights should be protected. If you waive them, they are not. According to Smith v. Maryland, there is no legitimate expectation of privacy and information voluntarily turned over to a third party. In today's case, Spryzen Wireless is that third party. Second, GPS technology is reliable and accurate. The defense's witness, James Fitzgerald, as well as the court-acknowledged expert Detective Peyton Thurber and Spryzen Wireless' Shannon Gannon, all testified today to the extreme accuracy of GPS, proving the worth of presenting such evidence at trial. Because this technology is so accurate, it serves as usable proxy for visually observable behavior and holds no legitimate expectation of privacy as ruled in the United States v. Forrest. Third, according to United States v. Knotts, the Fourth Amendment does not require a warrant to electronically monitor a suspect's location. As Justice Rehnquist ruled, visual surveillance from public places would have sufficed to reveal all of these facts to the police. Nothing in the Fourth Amendment prohibited the police from augmenting the sensory faculties bestowed upon them at birth with such enhancement as science and technology afforded them in this case. The court held that monitoring signals constituted neither a search nor a seizure under the contemplation of the Fourth Amendment. As Peyton Thurber stated, national trends and the local police department protocol are also in accordance with the ruling in Knotts, and therefore with the Constitution itself, despite the defense's claims. The defense continues to question why Detective Thurber did not obtain a warrant. Could he have obtained a warrant? Yes. Would it have been more precautious? Maybe. But did he need a warrant to use the location information? Absolutely not. The defense may try to argue on the basis of a privacy that a person generally has within their own home. Although Ms. Delane feels comfortable with Storm in her home, even stating that Storm grew up before her own eyes, let's be clear. In reality, that is not Storm's home. His mail and his identification cards are addressed not to the Delane house, but to the home of Tom and Mary Jackson, his parents with whom he actually resides. Spending time with someone and trusting them in your home does not in any way mean that they live there, at least not in the eyes of the law, where vague emotional ties must be set aside for purposes of clarity and reality. Storm certainly does not have an expectation of privacy in a residence that is not his own, including the residence of the Delane family. Furthermore, this case boils down to one issue above all else: Jackson's consent. Whether you agree with the terms of a contract or not, whether you understood it or not, whether you read it or not, once you sign your name to a contract, you are bound to its terms, as James Fitzgerald admitted. This trial is not to determine the legitimacy or the lawfulness of the contract. If we were considering the contract itself, the Jackson family would be suing Spryzen Wireless. However, this is not the case. The contract and its terms, at least as they pertain to Detective Thurber and his execution of career in law enforcement, stand regardless. The Glen Police Department and this honorable state of Ohio cannot be denied evidence at trial due to the negligence of a customer to read the contract he now regrets upon allegedly committing a crime. For this reason, we ask that you find in favor of the prosecution and deny the defense's motion to suppress Storm Jackson's lawfully obtained GPS location data. Thank you.